Yes, Mr. Pennington-Bensham.
Thank you. May it please the board, I appear with Mr. Nicholas Lear. Mr. David Halpin appears with his co-counsel, Midge Morton. Can I start off with the embarrassing bit just to say thank you and apologies in the same sentence for the adjournment on occasion.
Is there need to apologise?
I'm grateful. Anyway. Thank you very much. So I'll just start with an outline, if I may, of what we propose to say. It's effectively a game of two halves. First of all, there are some important questions of law and principle that the Court of Appeal has invited the board to give guidance on in respect of the correct tests for strikeout or want of prosecution and abuse of process. And we will be going through what we say are material errors, both of law and of principle, in the Court of Appeal's decision on the application. We will say, in short, that the Court of Appeal erred in law by applying the wrong provision of the CPR to the application, and that it also erred in failing to consider alternative orders that could have been made and failing to appreciate the last resort and draconian nature of the relief that was being applied for. The second part of the case concerns effectively, well, that's all very interesting, but does it help the appellant, given the facts of the case and the admitted significant periods of delay? And we accept in that regard that we would have needed an extension of time. And Mr. Lear is going to put some flesh on the bones in respect of that, but I think it's important that I just set out what we say is the correct way of dealing with a situation where somebody makes an application for strikeout, but the respondent to the application does need an extension of time to continue. So obviously that does create a slightly odd situation. We submit that it does not involve simply downgrading the strikeout application to an extension of time application, which is what happened in this case. We've wrestled with various different ways that these two applications effectively could be dealt with. And in the end, we have come down to the position that really the only sensible way of dealing with it is to have regard for both sets of considerations. Because in the end, it's not fair if a party requires an extension of time for them to take advantage of that by having the higher threshold principles applied. And therefore, you should have regard, we say the court should have regard to both sets of considerations. So if the court was to consider, in this case, strikeout first, if that application succeeds, then obviously that's the end of the matter, no extension of time. But even if that application is rejected, it doesn't necessarily mean you get an extension of time, but we would say the court would need to consider the extension of time principles, mindful of the fact that it's just ruled that it's not just and proportionate to strike out the claim. And we say that the four-part extension of time test should be supplemented by specific consideration of proportionality and mindful of the consequences of not granting a extension of time, which of course in effect is a strikeout. So we say that's how the court should grapple with a situation where there's one application before it, but the other party needs an extension of time. Mr. Lear is going to expand upon that a bit and go to some of the authorities, but it's important just to set out our stall, as it were. Finally, on this point, relief from sanction, we say that there is no doctrine of implied sanctions in the Eastern Caribbean Supreme Court system. I appreciate Justice of Appeal Barrow said something different in about 4 or 5 cases, actually, in between 2004 and 2006, sitting as a single judge. But since the decision of this court in a case called Kendon Matthews, that's really sort of knocked the nail in the head of all of that. So the relief from sanctions provisions apply where there is a specific sanction imposed by the rules and not otherwise. Again, Mr. Lee is going to deal with that, but I just want to set out our position. Assuming we do establish errors in the Court of Appeal's approach to this matter, and we persuade the board that those errors are material, we say the decision should go back for the Court of Appeal to consider the correct principles. This is a case that the appeal itself has significant merit, it's of significant value. The land inferentially is worth between 10 and 13 million US dollars. That's certainly the sum left over, as it were, from the compensation the government was ordered to pay. And we will submit that it cannot be said that the delay in this case is so inordinate and egregious that no court on a remission applying the correct principles, and in particular thinking about alternative orders that might be made, would necessarily come to the same decision. Can I just deal, that's the outline, can I just deal with 3 preliminary points before I get on to looking at some of the case law on abuse of process and want of prosecution. The first preliminary issue is that this is an error of law / error of principle appeal. We don't come before the board seeking to challenge findings of fact, or and we don't advance a frontal challenge to the exercise of a discretion. We say that the Court of Appeal wrongly directed itself. So I see the cases that my learned friend has drawn the board's attention to. We're all very familiar with those cases, Henderson and all the rest of it.
So the court's evaluation of the merits was that these were, it's not a strong appeal. But you're not challenging that then, because that's part of the evaluative judgment of the Court of Appeal.
Yes, I don't think we could we actually say the appeal is stronger, and we put in some cases.
Well, I know you just said that, that's why I'm asking.
But no, I mean, it's right that those points really we're stuck with. I mean,
You're stuck with them.
We're stuck with the fact that it's arguable, but we do say actually, as it happens, it's more than arguable. But we don't expect the board to make a decision on that, because all we need anyway in terms of meeting that threshold is an arguable appeal. But obviously, it would be remiss of us not to point out from the authorities that actually it's quite a strong bill, because the authorities on concurrent obligations are actually pretty clear, we say.
So you're not asking us to look behind the Court of Appeal's assessment?
No, but it's in our case, and it's something that we say. But no, I can't in the end ask the court to do this. We are looking at errors of principle. Those are the two points, as I've said, the wrong route under the CPR and the failure to look at alternative options. Plus, we will also look at prejudice, because that's something the Court of Appeal has asked the board to provide guidance on. Secondly, in terms of the discretion of the Court of Appeal, again, we accept that for want of prosecution, for example, an applicant needs to establish inordinate and inexcusable delay, and either serious prejudice or a fair trial just isn't possible. These are necessary but not necessarily sufficient findings, and the court isn't bound to strike out if those factors are present. So to that extent, we accept there was obviously a discretion to be exercised, but we do emphasise probably an obvious point, that it's not a freewheeling dispensing power. It's a discretion that falls to be exercised in accordance with very well established and long-standing principles, that it's a relief of last resort and so on. Finally, and I will come to this in more detail shortly, but we do resist significant reliance on the pre-Court of Appeal delay, because, and in particular, the submission that's now made before the board for the first time that this is a case of warehousing and it's an abuse, because that was not how the application was run in the court.
It must be relevant that it's a very stale case, regardless of whose fault that may be, on any view.
It's a very stale case, and it must be right that there's been delay on the part of the claimant. But what we don't have is evidence of the relative responsibilities for the delay, because defendants have also got a duty to push cases along, and we don't know you don't have any evidence of without prejudice.
No, but the background to appellate delay is this is a very stale case already.
Yes, I accept that as a background fact, it's perfectly okay to have regard to the fact that this is a stale case, but what we can't do, resubmit, what we shouldn't be allowed to take place is for the respondents to rerun a new case. That this is a case of warehousing, and actually the claimant's had no intention, the appellant had no intention of proceeding with the claim and so on, because there's just no evidence led on any of the delay before the Court of Appeal. I'll come to that point in more detail in a moment. But that's obviously important, because however unnatural it may be for any tribunal to focus on the Court of Appeal delay only, that is how the parties decided to run the application. So, case law on wanton prosecution and abuse of process, obviously a limited amount of time, the board will be very familiar with the cases, and therefore I just want to very briefly deal with one or two points by reference to passages in our case. Can we turn to page 1518, first of all? So the familiar test for want of prosecution.
But this is all pre-CPR, Burkitt and James and Wycliffe Baird.
It is.
Why are we concerned with that? We've moved on.
Well,
I mean, those were concerned with cases considering the old rules and the old approach.
well, that's the basis of the application. It was made on the basis of want of prosecution outside of the rule.
But nowadays you look at that in the context of the rules.
Well, you do in England and Wales.
Therefore, I object it.
Yes, well, you would look at both, yes, but you still have to, I mean, the application was made on the basis of this is a want of prosecution case, and
But they weren't saying, look at Burkitt and James. They were just saying this is a delay case, and it's appropriate to strike out.
Well, I'd have to look back at the application, but I think certainly the twin basis of it was Hunter, the decision of Lord Diplock in Hunter, which is the abuse of process case, and want of prosecution.
Yes,
and
not
as a
Burkitt and
doctrine.
James, those cases.
Sorry?
Not Burkitt and James.
Well, I don't know any other. I mean, that is in Weingartner, 2009 Privy Council decision. That is still the common law.
But that's pre-CPR. I mean, it's all changed, and here and there, surely. I mean, I can't think of any English case that now looks at Burkitt and James, or any of those old cases.
Well, it was. There is no provision under the CPR, as far as I can see, for striking out on the basis of delay. But you are still looking at want of prosecution. You do still have modern want of prosecution cases. Indeed, we'll go to one in a moment from quite recently. So I don't think there is a provision under the CPR. I think
there's abuse and there's breach of the rules.
There's breach of the rules only.
Orders.
Yes, that's right. So there's breach of the rules. You can strike out for breach of the rules, but strike out for abuse and strike out for want of prosecution are still common law applications dealt with in the inherent jurisdiction of the court to control its own processes. And
There's a particular rule that deals with abuse.
we say no, only if the statement of case itself is an abuse.
But that applies equally to notice of appeal. I mean, that rule applies in the appellate context expressly.
Yes, but the notice of appeal itself is not an abuse. It's the delay that's an abuse. That provision is not concerned with striking out for abuse. There is no provision for striking out for abuse. I don't think there is in the English rules. I think that those matters are left to be governed by the inherent jurisdiction of the court to control its own procedure, and they do still apply. I mean, it's still Burkitt, James and Burkitt, but with the addition of the development of warehousing.
With the addition of?
Warehousing, so the
Well,
concept.
not just warehousing, it's the whole focus on the rules and the overriding objective, and parties having their own obligations, because the courts have limited resources, to progress cases efficiently, within time limits,
Yes.
because it affects other litigants as well.
Yes.
So the whole approach is different since Burkitt.
Well, it's
Since
certainly,
the introduction of the rules, I mean.
yes, certainly the main, yes, certainly you would have to apply the overriding objective, and in particular proportionality, which is one of our complaints.
Well, proportionality is a second stage question. You first got to look at whether there's been some conduct that warrants the potential sanction.
Yes.
And when you're looking at that, I would have thought the rules are critical to the consideration. And going back to Burkitt and James seems to me to be very odd, because it was before those rules.
As I say, I don't think, I mean, other than the breach of the rules and orders, there isn't a provision under the rules that is engaged for delay.
Well, there is a general rule in 1.3, isn't there? Obligation on the parties to assist the court in furthering the overriding objective. And when you look at what that means, that includes getting cases on and dispatching them efficiently. Is
Yes.
that not relevant?
It would be relevant, but it's just, I don't think it's don't think it gives jurisdiction to the court to strike out. The court is still, if you look at the Cable, the Court of Appeal decision in Cable, and in the Alphonse case, which we'll come to in a moment, you're still applying, as I see it, the common law concepts. But overlaid, I accept, by the overriding objective and principles of proportionality.
Another way, you accept the court has an inherent power, never mind what rules say,
Yes.
to strike out,
Yes.
whether for abuse or prosecution. But surely in thinking about those concepts, take the concept of abuse, does that not have to be considered in the context of the CPR,
Yes.
including Rule 1.3?
Yes. Yes. But nonetheless, we do say that when it's purely delay, that does not amount to an abuse.
Yeah,
in
that's
an
well
office.
established.
Yes.
Delay by itself is not
Yes.
enough.
Yes, that's right. Can I just ask the board to turn to the decision in Weingartner at 2300?
Is that to make the point that delay by itself isn't enough?
No. it's just to bring to the board's attention paragraph 7 and 8 of that decision. And in particular, the Grovit and Doctor point, that where there's been a delay to prosecute an action and there's a finding on the evidence, that's the point over the page on 2301, that the plaintiff had no interest in actually pursuing the litigation, it may be possible to find an abuse effectively where the claimant is warehousing a claim. But that is a recognised category of abuse, but it's based on the evidence, we say.
Another recognised category is wholesale disregard of the rules.
Yes, if there really has been a wholesale disregard of the rules. I mean, in this case, there's been delay, we say.
And disregard of the rules.
Well, there's been a breach of the order made at the June 22 hearing to file the record of appeal.
Well, there's a breach of the rule not to file the record, breach of the rule not to file a skeleton argument.
Yes, that's right. Those are the two breaches. Plus, but it's effectively delay in breach of the order. Yeah. It's not a wholesale disregard for the rules.
We're at an appeal stage, so there are far less steps to be taken than if we were at the original trial stage. That does suggest a rather wholesale disregard in relation to the appellate process. You can't. What else could you have disregarded? You haven't filed the record and you haven't put in your skeleton argument.
Can I just turn to page 1523? This is paragraphs 35 to 36 of our case. The point made by Professor Zuckerman that effectively both limbs of the want of prosecution test as originally formulated were driven by justice on the merits philosophy. So that's why we look at serious prejudice to the parties as a result of the delay, or whether a fair trial is possible. So the focus is on the deleterious effect, if any, on the non-defaulting party. And he criticises that, I accept, and says that the effectively thereafter the response to that is to look at warehousing. So that's a way of that's a new category of abuse that's effectively created by the courts.
He's making a broader point first, isn't he, about the normative force of rules and time limits, and that's the point that the CPR has changed the approach.
Yes. Yeah. So I accept that, and we do accept that you have to look at these doctrines, certainly through the lens of the CPR and proportionality, which we say didn't happen in this case. But I do accept the point said effectively against me by my Lord Hamblin. You're not glued, stuck in time to a case from the 70s under the old rules of the Supreme Court. You obviously do look at the CPR, but that is still, as I understand it, the jurisdictional basis of striking out for delay. Other abuses of process, of course, concerned not with delay. We cite the Cable and Liverpool Victoria case, paragraph 25. Examples given there of putting the wrong value on the claim form in order to pay a different issue fee and so on and so forth. But those are types of abuse that are unrelated to delay and not in play in this particular case. And then the overarching point that we do pleonate is Lord Hope's judgment in the Summers and Fairclough Holmes case at paragraph 28 of our case. That's at 1520. He refers there, both under the strikeout, a statement of case for abuse of process under the inherent jurisdiction of the court and the CPR. The court accepts the submission that in deciding whether or not to exercise the power must examine all the circumstances of the case scrupulously in order to ensure that strikeout is a proportionate means of achieving the aim of controlling the process of the court and deciding cases justly. So I think that's really my lady's point. You do look at the CPR and proportionality and the overriding objective.
Well, I'm looking at, I think that it's a two-stage approach. You first have to look at the conduct.
Yes.
And I was talking about the conduct stage rather than the proportionality stage. Because in looking at the conduct, and whether there's been an abuse or delay in relation to compliance with rules, then you are affected, aren't you, by the fact that the CPR is in place with all the obligations it imposes on parties to further the overriding objective.
Yes. So I suppose the way to square the circle would be to say, yes, if the question is, has there been an abusive process, that question would be answered differently under the CPR. I think I would accept that.
Yes.
Yeah.
I see the point. I'm sorry. It took me a while to get there, but I think that's the point. In Asturian, yes. Right. Just following over onto the next page, so 15.2.1 of the electronic bundle, and Lord Hope's observation that one other point about the CPR is that it obviously, whilst ushering in a stricter regulatory environment, there are also powers and opportunities to make the sanction fit the breach, and that striking out a claim is always a last resort. And we say that those same principles apply in the Eastern Caribbean Supreme Court. And in terms of what Lord Hope means by last resort, it's useful to see, it's actually a warehousing case that's relied upon by my learned friend called Al Fawzan. So it's at 1717 of the bundle. And at paragraph 7, just note that the application is expressly brought on the basis that the claim was being proceeded with without any intention to progress it, amongst other things. And as a summary of the relevant principles at paragraph 12, may be an abusive process for a claimant to warehouse a claim by taking a decision not to pursue it, even if the claimant subsequently decides to pursue it. Mere delay, we've got that point from Asturian and many other cases. And the two-stage process at paragraph 12C, and can I just invite the board to read the extract at paragraph 13 of the judgment. There's obviously several points we would plead in aid there, certainly in terms of the appropriate response under the CPR. Striking out is more likely to follow an unless order once that's been sought and breached. That any question of a lack of intention to prosecute a claim will be tested, for example, by making a peremptory order, usually. And that striking out for abuse is a residual long-stop jurisdiction, and also obviously the rights of fair trial under Article 6, under the Constitution in this context, of course. Paragraph 16 on the next page. Five lines up from the bottom. I accept that the power to strike out is a long-stop jurisdiction only to be invoked where other powers appear insufficient to achieve the purpose of progressing the claim. But where the court is satisfied that a claimant has no intention at all to progress the litigation, I would see the doctrine of proportionality as not being a bar, effectively, to striking out. And this is why we say, effectively, the respondents are seeking now to run a case of warehousing, because it's seen as a way of cutting across this, because it's an accepted category of abuse, but that was never run below. But certainly the point I'm making at the moment in any event is that a last resort is focusing on when it would effectively be a waste of time to make any further directions or orders, because it wouldn't get the litigation moving. And just note the point at paragraph 17 that it's incumbent also on defendants to push matters along. So there may well be fault that will be attributed to the respondents as well as the appellant for the delay before the Court of Appeal, but none of that has been put into evidence. In particular, we say the strike 41, yes. Sorry, where is it now? 17. Paragraph 41. Is this where the
1736.
Thank you very much. Yes. Well, this is certainly the point that we make. I was going to develop later, but I can deal with it now. But it's an objection, effectively, to running the warehouse claim, because there's no evidence. I mean, this is a case where the application was put on the basis that the claimant was warehousing the proceedings. Evidence was filed by both parties. The claimant didn't put forward satisfactory evidence.
It may be said against you that in this case the failure to file the record, despite the fact that the claimant had received it, without any adequate explanation for that failure, was tantamount to an intention not to pursue these proceedings.
Well, we would resist that. Certainly, that wasn't the basis upon which the application was put, and therefore...
Well, it sort of was, wasn't it? I mean, it wasn't the respondent saying they've done nothing. The record hasn't been lodged, and there's no reason for them not to have done so. I think you were waiting for the court to notify you, but you had it.
Yes, and then there was an explanation given as to why, was the difficulty retrieving certain documents that were in...
That was much later on.
Yes, much later on. And so what was being said was, you're demonstrating no intention to prosecute this appeal. I mean, they may not have labelled it warehousing, but that's... the substance of the argument was to the same effect, wasn't it?
Well, we say no. It was just put on the basis that there's been a delay that amounts to abuse, and the Court of Appeal didn't address itself, didn't direct itself in accordance with the authorities on warehousing. And if one looks at this decision, there are several references, for example, in paragraph 18, to the focus being on the state of mind of the claimant. It's a very serious thing. I mean, I state the obvious. It's a very serious thing to say someone has abused the court system by not... but by warehousing a set of proceedings. I mean, the claimant, the appellant in this case, the claimant below, obviously isn't going to get any money or the land unless he at some point progresses the claim or succeeds on the appeal. So it's quite, I mean, given it's worth about $10 million of beachfront land, it's quite an inference to draw that there's no intention to prosecute the appeal. They obviously did want to prosecute the appeal. They just delayed for various different reasons. But it's not fair or appropriate to start, we respectfully submit, to make those sorts of inferences for the first time on an appeal to the board. Related, I may as well make the submission now, a related point in that regard is that the application to the Court of Appeal was focused entirely and exclusively on delay in the Court of Appeal. So there was no reference in the application or the evidence, apart from in very general terms about the fact the proceedings begun in 1991. There was no reference to periods of delay and whose fault it was or anything like that. So the evidence similarly was constrained and limited to the matters in the Court of Appeal. And that's something...
But in considering the significance of that delay, one looks at the context of the previous delay, no matter whose fault.
Yes, I think, my Lord, yes, I think I'd be constrained to accept that the court can't just completely put it from its mind that this is a case that's been lingering for a very long time. But there are other periods of delay. I mean, there was 3.5 years waiting for the judgment of Madam Justice Carter. There was a year waiting for the judgment of Thomas J. So, you know, there are very significant periods of delay that are attributable to other things, and we need to be a bit
Which makes
careful.
it incumbent upon the parties to advance matters without delay.
Well, my Lord, there are, with that sort of submission, there's always two ways of looking at it. I mean, one way I accept you would say, well, look, if there's been delays in the court system, we get on with it. But equally, it also potentially explains why there was missing documents, mould outbreak, and unable to find documents and so on and so forth, because things aren't being proceeded with within the court system. And so I'm not blaming it on the court system, I'm just saying that actually compliance with rules, practice directions and orders is to some extent a matter of legal culture. And there are two, you know, I don't want to make this point too firmly, but there is a world in which a Court of Appeal might be somewhat reticent to throw the rule book at someone for delaying in the prosecution of their appeal when there's been something like 5 years of judicial delay in the system. What was I going to say? Oh, yes. So, the Court of Appeal accepted yes, so page 388, please, with Court of Appeal Judgment, paragraph 2. The Court of Appeal there says, for reasons not explained in the judgment under appeal or in any of the documents filed in the appeal, indeed nowhere, 16 years after the claim was filed, the matter came up for trial before Belge that was on the preliminary issue in 2009.
So that's before any judicial delay?
That's right, yes, that's right. And then Belge did not try the claim. We say because the preliminary issue as framed before Mr. Justice Bell was inappropriate. It was the one framed by the respondents, and then it didn't actually determine one important issue, which is whether both sides were ready to close. But then the point I'm making is that for reasons similarly unexplained, another 7 years elapsed, still unexplained judgment on the claim heard in May 2016 wasn't rendered until July 2019. 4 years. Yes, 4 years. So I'm simply making the point that the Court of Appeal didn't have before it any material on which it could attribute respective blame for any of these periods of delay, because that's not how the respondents had made their application. And we say that they achieved an advantage in doing that because they had a choice. They could either make the application solely restricted to the delay in the Court of Appeal And that makes we have to accept, it makes a clean and crisp application where we are the bad guys and they are the good guys, because we're responsible for the period of delay and they aren't. Or they could have run the application on the broader basis of delay in the Court of Appeal and delay before the Court of Appeal. And we say respectfully that would have given rise to a very different picture, because we had serious things to say about their delaying tactics, what we considered to be their delaying tactics, in particular in respect of how they persuaded Bell J.
Well, now we're going to areas that aren't covered by the evidence, aren't we? You just told us we haven't gone into the explanations for the background.
No, I'm just saying. I mean,
the fact of the matter is, whoever's fault it was, this was a very stale claim, and that's the context in which you then consider further delay.
I accept that in a broad sense, but it's important not to get to a situation where the fact that there's been significant delay is just all landed on the appellant's doorstep. And it said, oh, well, there's been delay in the Court of Appeal, but look, this is a terribly old claim. Obviously, the Court of Appeal was right to kick it out. We say that's just too simplistic and unfair an approach in circumstances where the respondents chose below to narrowly constrain and frame their application in the way that they did. We can't now seek to gain advantage by saying, oh, well, look how long the claim's been out for, and it's all terrible and it's all the appellant's fault. Because in the end, it's us, it's the appellant that will suffer because of that. So it's relevant, we say, but only as a background fact. The power to strike out is not there as a punishment. It's used, we submit, when any other order would effectively be a waste of time. The ultimate role of the court is to decide trials and appeals on their merits. There's obviously an appeal as of right in this jurisdiction. And we know from the human rights case law that appeals are effectively part of the fair trial process. These are not new concepts, even to the Eastern Caribbean Supreme Court. So these concepts of strikeout being a remedy of last resort, the importance of looking at alternative remedies and so on. Can I just ask the board to look at paragraph... no, scrap that, sorry. Let's go to the case of Campsall, which is at 1824. Is that right? Yeah. One can pick up what that case is all about just from reading the first summary paragraph on page 1824. And I'll just pick up the judgment at paragraph 18, which is at page 1834. Striking out of a party's statement of case, denying him access to the courts to determine his case, or in this example, his appeal on the merits as a draconian sanction, should not be resorted to immediately without exploring other options. And then there's reference to the decision in St. Lucia Furnishings and the observation that civil courts, obvious though it is, are established for deciding cases on their merits. A flexible approach should be adopted. I particularly mention the provisions relating to unlessors, which are intended to be used as a preliminary step to the imposition of sanctions. And then a further extract from the same case in the next paragraph. Well, there will be situations where striking out without the intermediate step is an appropriate order. For example, repeated non-compliance combined with a weak case could justify striking out of the case. The remedy, and the relevance in particular of the merits. I think the merits does assume more relevance in the Eastern Caribbean court system than perhaps it does in England and Wales in these sorts of cases. And then over the page on to paragraph 20. A summary of those principles. So these are not new principles, but they are principles that were not applied in this case. But they do form part.
No one was suggesting a lesser sanction.
It's true that no one was suggesting a lesser sanction, I accept that, but nonetheless it was incumbent upon the court, we respectfully submit to. The difficulty in this case is that there were at least 2 Court of Appeal decisions saying that the test for strikeout for want of prosecution or abuse of process was the 3-part test. That's 4-part test.
And you accepted that?
And we accepted that because it was unanimous Court of Appeal decisions. I mean, they were bound by them. I mean, the Court of Appeal was bound to apply its own law, hence the reason we got conditional leave. But the difficulty is, yes, once there's no getting away from the fact that everybody accepted that at the time that those were the correct factors, and that meant that proportionality just didn't come into them. There's at least 4 cases in the bundle concerning cases where the court is applying an extension of time analysis, the Rose and Rose 4-part test, and in none of them is proportionality referred to. It just doesn't come into the test. It's just you just apply those 4 factors.
But those factors are clearly relevant, as you accept.
Yes. Oh, yes.
And you say, but you've also got to consider proportionality.
Yes. On top.
Right.
Because the consequence of refusing the extension of time is in effect that your case will be struck out, and therefore one needs to consider whether that's a just and proportionate outcome. Given in this case, well, I'll come back to that.
But isn't that inherent in the discretionary stage? The court must have been well aware of what the consequence of strikeout would be.
They were must have been well aware that if an extension of time is not granted, then obviously the appeal goes, but they didn't address their mind. And part of the discipline, we say, of applying the proportionality test is you have to address, the court has to address its mind on the one hand to the sanction.
They recognise it was a nuclear weapon.
Yeah.
Yes, but that's not, with respect, that's not good enough. It's simply going to the end result. The whole point of the proportionality assessment, there's no reference to the strikeout being a remedy of last resort.
Well, doesn't nuclear weapons suggest it's a remedy of last resort?
Well, not in the true sense of that word, as I've been trying to explain. Our understanding and our submission on what is meant by last resort is the court has to go through the process of considering alternatives and whether those alternatives would actually get the piece of litigation going to a judgment on the merits in a way that doesn't unduly prejudice the other side. That's the point. So a last resort is not just saying it's a nuclear weapon, it's saying, well, are there any other orders that I could make before making this?
You didn't even suggest any.
Oh, well, I accept it.
The 4-part test, even if applied, doesn't automatically lead to a strikeout, does it? I mean, there is a stage where the court still has to consider, and the court appears to have considered, for example, the overriding objective. It refers to what is just. Is proportionality not inherent in that?
Well, it's part of the overriding objective, yes, but it's not been expressly applied. And it's, as I say, the difficulty here is it's all very well saying, oh, this is the nuclear option, but they've behaved very badly. That's using it as a punishment. What should happen?
So you're using it as a
punishment. What should be happening instead is what's been suggested in the other case, the St Lucia case, is that you look at alternative options and whether any of those might feasibly drive the litigation through to a decision on the merits. I mean, the fact this has been hanging around, this piece of litigation, for a long time, I mean, could conceivably be a good reason not to strike it out. I mean, we're right at the door of a final decision by the Court of Appeal. There was no live evidence before Carter-J. It's purely submissions-based. The appeal could have been decided in one day, possibly less. It's a very short point about whether the respondents were also ready to close. Because if they weren't ready to close, then the fact that we weren't ready to close doesn't matter anymore, to put it in very basic terms. It's a short point. Could have been dealt with in a day, and instead what the Court of Appeal does is spends 2 days on a strikeout application and then jettisons the case. And we say, well, respectfully, that's not using the strikeout as a remedy of last resort.
Are you saying that because the Court of Appeal was bound by its own earlier decisions, it wouldn't have been open to you to say, look, you can do something else, and here's the something else you could do?
No. We could have said, you should also, I mean, I haven't been through the transcript recently, so it may be that we did make submissions about proportionality, I don't know. But, well, I'm being told we didn't, but we certainly didn't make submissions about alternative orders. And I think I have to accept that it would have been open to us, yes, to have said, well, hang on a second, why don't you do this? I can't say that, but that's not how, as I say, the 4-part test seems to work. I think...
So apart from proportionality, is there anything else wrong with the 4-part test?
Well, I think the other point is, the other difficulty that's perhaps related to proportionality is prejudice, because the Court of Appeal doesn't consider...
Well, it considers the merits of the claim, doesn't it? So it must be considering prejudice in that context.
Well, we can turn up the Court of Appeal's decision, because paragraph 45, I think it is, which is on page 403.
That paragraph comes after the court has said that the merits are not strong.
They recognise it's an arguable appeal.
Recognise it's an arguable appeal, exactly, but then talks about the prejudice to the litigants. Now, the analysis there effectively is, well, the court only looks at the prejudice to the non-defaulting party. Now, in the context of the 4-part test, that makes sense, because it's not as if the appellant, the defaulting party, can be prejudiced by their own delay, which is the point made by the Court of Appeal. In the middle, besides, the appellant made no assertion that he suffered any prejudice by his own delay. That's obviously correct, but the point that matters is the prejudice of being struck out from your claim, and that's the consideration that takes primary position in a strikeout application. So there's a problem. If you apply this 4-part test to a strikeout application, you don't get at the right principle.
But if you're concluding that even though the appeal is arguable, it's not one with a strong prospect of success, what's the prejudice? You've already lost, and the court is evaluating the likelihood that you will be successful on appeal and saying you haven't got... This is not an appeal with any strong prospect. So that's the prejudice you're talking about. They've addressed it.
Well, respectfully, I wouldn't read... I mean, they say it's at least arguable in paragraph 40.
No, but I'm looking at 47.
Yes.
47, they say in terms it's arguable, but it cannot be said to be an appeal with a strong prospect of success. So what's the prejudice?
Well, because it's still an appeal with a prospect of success. The reason why...
They're recognising that. But,
yes.
but that's where they deal, in a sense, with prejudice. They may not call it prejudice.
Well, I think that would be respectfully a very generous. I mean, what needs to be done is the court needs to consider whether, at this late stage of the game, in circumstances where you could have a one-day appeal, submissions only, no evidence, and resolve this thing on the merits, why at that stage it's just and proportionate to strike out the claim. I don't think that's answered by simply pointing to the fact that the Court of Appeal looked at the merits. It's not good enough.
Well,
And the reason
they are bearing in mind, aren't they, the fact that your delays discourage other litigants, or have, if they are tolerated, encourage a culture of not enforcing the rules and not complying with the rules, and resources of the court have been taken up with this application rather than, as you say, getting on with what should have been a one-day appeal, which would have happened quite a long time ago at the point at which the Court of Appeal is dealing with this, if you'd satisfied your own obligations to file the record and your skeleton argument.
Yes. But it doesn't say that, does it? It just says.
Well, that.
It just says. The reason, by the way, the court we submit is saying it's not one with a strong prospect of success is because there is a line of case law in the Eastern Caribbean Supreme Court that says if you have a strong case on the merits, then that can override even very significant periods of delay. So it's particularly forgiving. So it has to identify which category it falls in. But I don't think they're saying that this is one that's doomed to fail. I mean, that's just to be clear on that point. I mean, it's arguable, but it's not one that's
which case are you referring to in terms of?
So that is two. There's a number of cases, but probably the best one is Joseph Hyacinth. So that's at 2431. We'll pick up what the case is about at paragraph 1, which is at 2433. And this is and then at paragraph 4, which is at page 2435, principles for extending time to appeal. Again, the rows and rows test is used. Length of delay, reasons for the delay, chance of appeal succeeding, degree of prejudice to the respondent if the application is granted. And then we can pick it up, please, at paragraph 25 on 2442. And the extract from the case of Quillin, where obviously if the proposed appeal is hopeless, the application should be denied. On the other hand, if there were no substantial reasons to justify an ordinary delay, but prima facie there appeared to be some merit in the proposed appeal, the application should be granted. That's probably a bit overly simplistic. We would accept, but that's why the Court of Appeal is looking at the merits, because, as we can see in Edgecombe and another...
I mean, the context there was a delay of 6 months, which was found to be inordinate.
Yes, and then at paragraph 26 on the next page, extensions of time to appeal have been granted on the basis of the applicant's good prospects of succeeding on an appeal. So that's really what the Court of Appeal we say is getting at there. Is it's not in a category where it's so strong that you can overlook everything else, but nonetheless it's a properly arguable appeal. And we say.
So there appears to be fairly established jurisprudence dealing with delays and appeals. which involves the four-fold test.
Generally, for extensions of time, generally.
Yes. I mean, to what extent should we be getting involved in local practice?
Yes, well, certainly we did think about this point, and we don't seek to interfere with the developed practice that applies to extensions of time, save where we say a different approach should be taken, where the effect of refusing extension of time is that the matter comes to an end. So there's nothing wrong with the four-part test to extensions of time. If you need an extension to file a witness statement, for example, or something like that. But if the effect of the refusal of an extension of time is that you're out.
But these principles are set out in the context of appeals, where that is going to be the outcome. It is in all these cases.
Yes, so we would say in those situations that the court should look at the additional point about proportionality and alternative orders, yes. So it should be supplemented by an assessment of alternative orders, because otherwise insufficient regard is had for the draconian consequences of the refusal of an extension of time. But certainly,
Just to be clear, you are saying that the four-stage test identified or summarised at paragraph 4 of this judgment that we've just been looking at on page 2435 is inadequate and needs
in the
a second stage.
in the context of where there's a situation whereas here, where there's a want of prosecution application, for example, and an abusive process is someone's trying to strike out the claim, that application can't be answered, we say, solely by applying a four-part test on extensions of time.
But that would also apply on the facts of Joseph Hyacinth, would it not? Because that, in any case where you're seeking to extend time for appeal,
yes,
it's been put to you, you're otherwise out, and in the English jurisprudence, that's treated as an implied sanction.
Yes, yes. I think that's right. Yes, we say that it needs modifying by the addition of, but it's not a drastic addition. I mean, proportionality is part of the overriding objective. The only thing that needs to be done is to just have specific and particular focus on the possibility of alternative orders in circumstances where the effect of a refusal of extension of time is that somebody's shut out. I don't see that as a radical departure from the settled practice of the local court, so much as just guidance which the Court of Appeal has asked to be provided on how these sorts of applications should be managed.
Just going back to your submission that this, an alternative course could have been dealing with an appeal against Carter J's judgment, which could have been dealt with in a day. How does the last sentence of paragraph 43 square with that? Because the Court of Appeal highlight there that Madam Justice Carter didn't make a factual finding that the fifth respondent was unable to close.
Yes, I think that's the finding that should have been made. Well, on the document.
Finding wasn't made. So
Sorry?
how does that square with your contention that it's all a legal matter and an appeal could have been dealt with?
Because it's sorry, let me just make sure I understand the question. So which paragraph of the Court of Appeal judgment am I in?
43.
42?
3.
43, sorry. Yes, well, we say that the first sentence there, and it's arguable that had she determined that issue, she may have gone on, etc. We say that that was a foregone conclusion because it was accepted on the evidence by the respondents that the landholding companies, at least one of the landholding companies, wasn't on the register. So they weren't able to close. They didn't need any fresh evidence on that point. So if one goes to the decision of Madam Justice Carter. Just chase down that reference. Yes, so it's at page 208 of the bundle, paragraph 19. This was correspondence from the respondents, then defendants, to us, saying that they too wish to consummate the transaction. And then over the page onto 209 of the bundle, second point, it's now become apparent neither was Betts Reality in a position to close on that date, a fact which was not known at the time. I think there's a dispute as to whether it was known by him because there was an application to restore. But in any event, the point, it's an accepted fact that companies weren't on the register, and therefore we say, well, how could you close? How could you have transferred title on the day of the close?
But there's also an issue about whether this was dealt with in Belge's judgment, isn't there?
Well, I can deal with that. I mean, my learned friends suggest that somehow the point is res judicata or issue of stop or whatever. And we say it absolutely isn't, because of the way in which the preliminary issues were framed. So very briefly, we turn up the decision of Mr. Justice Bell. It's at 139. Could I then just ask, please, the board to turn to 140, paragraph 3. Our proposed preliminary issues are numbered there, A, B and C. And the second preliminary issue that we canvassed for was included B, were the claimant and the defendants in a position to close. The defendants, now the respondents, however, focused on just a single issue, whether the claimant or the defendants failed to close. So it was cast before Belge as if it was a binary position. It was either the claimant's fault or the defendant's fault. And it's common ground between the parties, and it's recorded in the judgment of Thomas J, that the judge, Mr. Justice Bell, decided the case by reference to the respondent's proposed preliminary issue. I'm slightly out of my terms.
Where do we see that? Their preliminary issue.
The respondent's preliminary is in paragraph 3, the bottom of paragraph 3. And it's again in paragraph 15 on page 143.
Right.
So that was the preliminary issue that held the day. I can't now find the reference, but it's in the judgment of Thomas J, who dealt with the strikeout application following this, following the judgment of Bell. He records 11. Anyway, it was an accepted position. That's the preliminary issue that Bell J decided. And what Bell J then went on to decide was, first of all, the claimant, now the appellant, was the cause of the failure to close, effectively because he wasn't ready, and he was, so the judge held, was seeking to make further amendments to the agreement and to continue the negotiations rather than close on the day in question. And there was also a suggestion that he didn't have the available funds at that time. So can we turn to page 161? Paragraph 37. So Bell J decided that even if the claimant could prove he had access to the funds, he couldn't prove that he attended the meeting preparing to close, and he goes on to make the various different adverse findings. And then the point that we were making before Bell J was, yes, but there's this other issue, which is even if we weren't ready to close, neither was the respondents. And the way that Bell J dealt with that is at paragraph 41 on page 162. Just to put some context to that paragraph. So what effectively the judge held was, if you had complaints about title, you had to raise those complaints, requisitions, earlier on in the process. That's what the option agreement required. And because you didn't raise those complaints early, within the 60 days contemplated under the agreement, you can't now rely on the lack of title. Sorry, you can't now rely on the fact that the landholding companies were not in good standing, were not on the register, to excuse your failure to close. But that left entirely open the separate and distinct question, which is, well, okay, let's take it as read that we weren't ready to close, but if they weren't ready to hand over title, then we weren't in breach. And that point isn't res judicata. That's why the Court of Appeal says that the appeal is arguable, because it recognises that that point isn't res judicata. Can I just have a couple of minutes to work out where I am, because I've gone out of order. So just in terms of what I think we've already submitted in clear terms that the main complaint we have about the Court of Appeal's judgment. But can I also just very quickly deal with the CPR route as well? So by the way, the CPR that's been copied into, the CPR provisions that have been copied into the SFI aren't the correct ones, because at the time it was governed by the 2000, not by the 2023. And as a second, by the way, the board will have noticed that the relief from sanction provisions in the 2000 rules are quite harsh. And although there's been a judgment of Mr. Justice of Appeal Jamadar from Trinidad sort of softening them a bit, but you still do have those preconditions.
That's been changed.
That was then jettisoned because it was felt, as I understand it, that it was better to have a broader discretionary framework, as you do in England and Wales. And then it wouldn't be so harsh to apply that, even in cases of an implied sanction.
Yeah.
It's obviously very problematic to apply the relief from sanctions rules to non-express sanction cases, because it has those three preconditions that must be. Right, anyway. 1639, please, 1639.
So is this the old rules?
This is the old rules that applied at the time. And we can see at the bottom there, 26.31. In addition to any other power under these rules, the court may strike out a statement of case if it appears to the court that there's been a failure to comply with the rule, practice, direction, or exactly the same as England and Wales, I think, more or less. Or C, the statement of case is an abuse of process. Now, the application was made on the basis of C, and it was decided on the basis of C.
But they're clearly relying on failure to comply with rules and indeed orders.
Well, we say if they did intend to rely on A, then a bit odd that they didn't make the application on the basis of A. Both the application and the Court of Appeal's judgment refer expressly with dots deleting A to C. And we say that the likely answer to that, I'm afraid, is that the case law under the correct limb, which is A, says very clearly that strikeout under that CPR route is again an order of last resort. So can I just
Does this get you beyond your main argument, or is it just another way of saying that proportionality should have been considered?
It is another way of saying proportionality applies, both if you use the express rule under the CPR, but it's an error of law because the Court of Appeal used the wrong limb, we say. But even if it had it have used the correct limb, it would have run into this case law.
But the four-part test isn't limited to 26.3c, is it?
No, so there were
cover 26.3a cases, and that's normally the perspective in which you look at it.
Yes,
focusing on breach of rules, breach of the orders, and over a prolonged period of time.
Yes, but if one is making, if one is looking at the breach, as my Lady Simler suggested to me, through the lens of the rules, then it's useful to have in mind the case law that applies to those particular routes. And certainly one of the bases of the Court of Appeal's decision was strikeout under the rules. So both in its inherent jurisdiction and under the rules, but applying the wrong rule. But in a sense more important than that, because of course if it applied the right principles, it just applied the wrong rule, who cares, basically? I mean, you can apply I don't take any issue with that. But the difficulty is if they had have made the application on the correct limb, they would have run into this case law that I'd just like to come to now. In particular, I'll just give some references rather than going to all of these, but we deal with this in our case at paragraphs 87 and 88, and paragraphs 49 and 50, so I'm slightly out of order. The one judgment I will turn to is a judgment from Trinidad, 2554. Real-time systems, judgment of the Privy Council. Lord Mance gives judgment. I think we can pick up the point at 2558 at the bottom of that page. This is, by the way, a case not from the Eastern Caribbean Supreme Court, but from Trinidad, but they apply the same, in this respect, the same provisions. So these decisions are referred to in the Eastern Caribbean Supreme Court system. At the bottom of page 2558, one of the case management powers includes taking any other step or giving any other direction or order for the purposes of managing the case and furthering the overriding objective. And then over the page, although differently numbered, because it's 26.2 here rather than 26.1, but it's the same provisions. Failure to comply with the rule or an abuse of process, a slightly different order, but it's basically the same provisions. And then I'd like to turn, please, to paragraph 17 of the judgment, which is at page 2563. And the point made by Lord Mance is that the court has an express discretion under Rule 226.2 whether to strike out. It may strike out. It must, therefore, consider any alternatives. And Rule 26.11W enables it to give any other direction to further the overriding objective. And it notes at paragraph, His Lordship notes at paragraph 18 that one of being invited just to allow the board, I think, to read all of paragraph 17. Is that right? Yes, thank you. Yes, thank you. And there's a provision in the CPR that I'm sure the board has seen where when a court makes a direction or order, it should, where reasonable, where reasonably practicable, state the consequences of a failure to comply with that. And it's also noted here at paragraph 18 that one of the parties, the centre, could in the present case have applied not to strike out, but for an unless order, failing which the statement of the case would be struck out. It'd be very strange if, choosing only to apply for the more radical than the more moderate remedy, a defendant could force the court's hand and deprive it of the option to arrive at a more proportionate solution. So we say, well, if the application had been made on the correct limb under the CPR, the Court of Appeal, both the respondents and the Court of Appeal, would immediately have to deal with this case law, which makes it expressly clear that alternative measures must be considered first. We do make one final point about prejudice. The test for strikeout, certainly for want of prosecution, is serious prejudice. Now, obviously you have to accept in a general sense.
You're going back to the old law again here.
Well, if that's the basis of the application, we've dealt with the application under the rules, and I've cited the case law there, and if the application is indeed in reliance on the common law, then it's a serious prejudice test, and we say that other than being kept from its judgment, no other prejudice was relied upon. Now, we obviously accept in a very general sense that being kept from a judgment is prejudicial in a general sense. But in circumstances where one is looking for additional prejudice caused by the delay, just relying on being kept from the judgment in the same way as being kept from other remedies or relief, or indeed a trial on the merits, is just repeating delay. Because it's the appeal itself that keeps the respondents from their judgment. It's an appeal as of right, and that's what keeps them from their judgment. The question then is, what additional prejudice over and above being kept from your judgment is caused by the delay?
There was a freezing order in place as well.
Yes, but there was no evidence filed below. I've been presented with a piece of
You've got an appeal as of right. If you complied with the rules, the appeal would have been heard. You've said it was a straightforward appeal, one day, would have been heard long, long ago. So there is additional prejudice because the defendants, the respondents, assume that they're going to win, and they've been kept out of their money for much longer than they would have been had you complied with the rules and pursued the appeal, furthering the overriding objective and complying with directions and orders.
Yes, but I'm simply making the point that in order to rely on financial prejudice, that there is an order here that the money be paid, the compensation money that was due from the government be paid into an interest-bearing account. And there was no attempt, as the authorities suggest there should be in the want of prosecution cases, there was no evidence that I could see that was filed on rates of return or anything like that. I mean, it's true that they were kept from their judgment, but
They can't use the money.
yes,
They've lost the opportunity to use that money in the ways that they would have used it.
Yes, it's right. In a very general sense, there is.
It's not general, it's very specific, isn't it? I'm sorry, I just don't understand why you say that there isn't prejudice.
I accept there is general prejudice, but in the want of prosecution cases, you need to show delay plus serious prejudice. And just by saying you've been kept from your judgment is just more delay. It's not an additional form of prejudice over and above the delay, because all delay necessarily keeps you from your judgment. So if you're saying delay plus serious prejudice, you can't just say, I've been kept from my judgment, because all delay causes that. The focus is on additional serious prejudice, which can be financial, and we've cited 2 cases in our...
Yeah, but it's not just the delay that's inherent in an appeal, it's a delay combined with an effective stay because the money was in court.
Yes.
Despite the judgment below going in the respondent's favour.
Yes, I mean, the appeal was on foot. A stay was granted for reasons that had nothing to do with delay or anything else before any of these delay issues occurred. So all of that was in place. And it's simply a question of identifying additional prejudice. But anyway, I mean, I can't keep repeating the same thing. But I think probably those are all the points I need to cover. I'm going to just ask Mr. Lear, A, if I've missed anything, and B, if he would like to follow on those points. Trouble later, but okay, fine. So I'll hand over to Mr. Lear then, just to finish up. Thank you very much.
Yes, my lords, my ladies, I'm grateful to Mr. Pennington Benton for handing over, and as he outlined earlier, I will address your lordships, your ladyships, on the questions of extensions of time and relief from sanctions. I have 6 submissions to make on those questions. In brief, firstly, the appellant needed an extension of time. Second, the Court of Appeal should have considered that need for extension in the round together with the strikeout application. Third, the Court of Appeal wrongly merged the tests.
You're going a bit quickly.
So sorry.
They should have considered...
It should have considered the need for an extension in the round together with the strikeout application.
Had you made an application for an extension of time?
At no point, no.
Sorry?
No.
No.
I'll come on to that, my lady, as to how it should have dealt with it in the absence of an application. But just outlining the points. Third, the Court of Appeal wrongly merged the tests for strikeout and extension. Fourth, the correct approach to an extension is to consider the 4-part test, but with the need to add proportionality and alternatives. Fifth, there was no need for relief from sanctions in this case. And finally, sixth, there is no doctrine of implied sanctions in the Eastern Caribbean. It might be that those latter 2 points I can address rather quickly. So turning to the first point, which is that we needed an extension of time. We, of course, accept this, and we deal with this at Section F of our written case, paragraphs 68 to 83. We accept we were out of time for filing the record of appeal and written submissions. Of course, there are relevant rules. I'll just give the court the reference at 1655. That's Rule 62.12.3, which is a rule about filing the record within 42 days of receipt of notice of a transcript. Now, of course, the board will have noticed that we contend that we never received that notice.
It's not the strongest point.
But of course, we accept that we got the transcript. But if I could just flag, the written submission rule is 62.10, subsection 4, and that's at 1654. That's simply the references for the board. What then happens is that there is a status hearing on the 13th of June 2022 in which the Chief Registrar ordered the appellant, and this is at paragraph 2, page 902 of the electronic bundle, to file the record of appeal and written submissions with authorities on or before the 6th of September. That order also makes provision there for fixing the hearing, the next sitting, on the week commencing 7th of November. Now, of course, those deadlines pass and are not conformed with. However, the matter then comes back before the Chief Registrar for Case Management on the 30th of September, and this is at 929. And simply that order reads, the matter is adjourned to the next status hearing scheduled for the 31st of October. I should say, and there is evidence of this, that at the case management on the 30th of September, it was put for the first time that there were difficulties with filing the record of appeal and that they were looking to adjourn that hearing during the week of the 7th of November. Both Court of Appeals in the strikeout and also grant of leave judgments refer to that. Paragraph 10.391 with strikeout and paragraph 12.487 of granting leave. Now, before an adjournment application was made, on the 13th of October, the respondents filed their notice of application to strike out or dismiss. And therefore, chronologically, we say that then what obviously took over was this strikeout application. And that is what then the parties dealt with and preoccupied their time. I should say, for reference...
You had to file the record, and you did,
yes.
Eventually.
Yes, I was going to say, my Lord Hammond, so at 391, para 13, it's referred to in the evidence of the appellant that on the 20th of March 23, the record is filed. On the 6th of April 23, the written submissions are filed, and the reference there is 292. So they were eventually filed, but we accept out of time, and in the absence of an application. I'm going to come on to that for an extension of time. So that's the second submission, is the Court of Appeal should have considered the need for an extension of time together with the strikeout application, even in the absence, we say, of an actual application for an extension of time.
And was that a submission made to the court?
To the Court of Appeal? No.
No.
As I understand, my lady.
So you're criticising them for doing something that you didn't ask them to do?
Insofar as we say that there is an inherent case management power to consider extending, and this is 26(2)(k), of extending times for compliance, that is within the case management powers of the court to consider these matters.
But you're...
Well, I can see my lady's question, which is, of course, we didn't ask for it, so why would we get it? We didn't ask for it, is the plain and simple fact, but we say that it should have been considered. But certainly it should have been considered on the grounding that the four-stage test was applied, and that, we're going to argue, is the test for extensions of time. If I can ask the board to turn to 2075, and this is the case of Costello and Somerset. And I'm going to pray and aid this case as an example of how, faced with this factual reality, the Court of Appeal may have dealt with the two applications. Just to outline the facts of this case, it was a personal injury case issued and served before limitation, but then the plaintiff fails to serve a statement of claims, schedule of loss, and medical reports in accordance with, and I accept this is under the old rules, the RSC, Order 18. There's a strikeout application for failure to comply with that rule and or warrant of prosecution. There is then an extension of time application. And the question there, and I'm going to turn to page 264C to H, and the analysis of Sir Thomas Bingham, Master of the Rolls as he then was, in how to deal with such an approach. And just picking up slightly below 264C, where it starts with the word where, as here, the defendant seeks to dismiss and the plaintiff seeks an extension of time, there can be no general rule that the plaintiff's application should be heard first with dismissal of his action as an inevitable consequence if he fails to show a good reason for his procedural default. It goes on, effectively to say, later in the paragraph, and I would invite the board to read this in full, that you consider both in the round, because effectively one can determine the other. Of course, in this case, if we were unsuccessful on the strikeout, there would be no need to consider an extension of time. But I lay this foundation because I'm going to come on as my third submission that you can't merge the tests. You do have to consider both on their own principles, trammelled carefully, but in the round. And it's this holistic... Do you want to read the next paragraph? Yes. This is, well, if you go further, and this is a part of 264, is this 264 F to H? Yes. Grateful to my learned friend. Yes, and this is a paragraph which I did invite the board to read anyway, all the way down to H, which is effectively outlining the context, and also, of course, cases where it's a well-known phrase, contumelious and intentional default takes place. One sees that phrase in the abusive process cases and wanted prosecution. But there is a helpful passage at the end of that paragraph, apologies, that says, in short, the very end, an application under, I'm afraid we don't have this order in the bundle, but Order 3, Rule 5, should ordinarily be granted where an overall justice of the case requires that the action be allowed to proceed. Effectively, that's an extension of time application. And it's that overarching framework of proportionality that I'm going to submit needs to be hung in the balance, and wasn't in this particular case.
Seems a bit dated, this. If you go back to the previous page,
Yes.
074, where the Master of Royal sets out the general principles,
Yes.
you'll see the second principle is that a plaintiff should not in the ordinary way be denied an adjudication of its claim on its merits because of procedural default, unless the default causes prejudice to his opponent for which an award of costs cannot compensate.
Yes.
Then that's effectively repeated in the paragraph you took us to on the following page. But that attitude that it's really a matter between the parties is, that's pre-CPR.
It is pre-CPR. Now, of course, there's ample guidance about this. There's a case in the bundle about called Anadeus, which is that of Mr. Justice Newberger, as he then was, outlining the difference between the RSC and the CPR. Yeah. We fully accept that. I mean, what we would say is Costello is an example of how one might deal with this particular reality. I can take the board to some more recent cases of this jurisdiction. If I may turn to 2684, which is a case of occupiers of Samuel Garside House.
I'm so sorry, can you give me the...
2684, my lady. We have cited these cases in our written case at paragraph 77, so I won't go into detail because only one of them is actually in the bundle, and that is this case. And what we have here was an application to extend time for service of particulars and also an application to strike out. Again, we have the two competing applications. And what we have from Master Dagnall, and this is only, of course, of last year, is a consideration of the matters holistically on the various points. Of course, what we see here is actually, in this case, the Master considers the application for extension of time first. This is 51, my Lord. What we see at 51 is that the Master actually considers the application for an extension of time first, and then whether or not that is successful, going on to strikeout. Now, I don't think we are going to nail our colours to the Master to which way round one does this. We say that it should be done in the round, but of course we do say very firmly that you can't downgrade an extension of time a strikeout application to extension of time principles, and equally you can't upgrade an extension of time application to strikeout principles. And if I can just point out at 51.6, Roman numeral, there the Master cites a case of Brown where, and that's the quote, it would be disproportionate to refuse an extension, which refusal would effectively lead to a strikeout of the claim, when the underlying evidence would have not been impaired by the delay in service. It goes on, that is to say, refusal and consequent strikeout would be disproportionate to the breach. That sets the scene for our fourth submissions. And the third is that the Court of Appeal, in this case, took the wrong approach, which was to merge the tests. Of course, it did so in the absence of considerations of proportionality and alternatives. But if I can just address how it dealt with these tests. Mr. Pennington-Benton has already gone through the correct principles that should have been applied. Where you start, in terms of extension of time, is the four-stage test. We accept that. It seems to be, as my Lord Hamlin pointed out, deeply embedded in the jurisprudence of the Eastern Caribbean, that you've got cases of Harold Simon, Monica Patsy, Rose and Rose. Goes back a long way.
No, but they're applied in the context of delayed conduct of appeals.
They are, in those particular cases, yes, but they also stem from a case, an English case, that of C.M. van Silvolt, which is at 1933.
Well, that's what you say, but they've clearly been repeatedly applied in the context of appellate delay.
Yes, but they seem to be taken, we would say, my Lord, as an example of how one deals with extensions of time generally. Whenever a period of non-compliance is reached, that is when the Court of Appeal in the Eastern Caribbean appears to be applying these four stages. There's also the example of Barbuda. Sorry. Yes, I'm going to get there. Timely reminder from Mr. Pennington-Benton, which is to move on to Montesir, which is actually a more recent case, and that is at 2623. This is coincidentally also a case of Justice of Appeal Michel, I believe, and it is a consideration of an application to strike out an appeal for failure to file the record of appeal and skeleton arguments, together with an application for an extension of time. And also, there, Justice of Appeal Michel does cite his former decision in, of course, this case, Wycliffe Baird. I've taken the board to this particular page because at paragraph 13, what the court does there is effectively says, at the hearing of the applications, the court considers to determine each application would be dispositive of the other, and effectively takes the approach of merging the two tests by saying very clearly, yes, the court accordingly decided to hear the applications together and directed the parties to address both applications in their submissions, the arguments for each being, in effect, the same. And we would dispute that. We say that these are different tests, fundamentally different anchors.
But as I understand it, you don't dispute the four-headed test for the purpose of appellate delay apart from the proportionality point.
Apart from proportionality and the need to consider alternatives, yes.
Well, that's part of proportionality.
That's part of proportionality. That's the second stage, and I think it's been referred to, of course, Asturian, the two stages one identifies. In that case, that's about abuse, and then one moves on to the discretion as part of the proportionality. But we say that certainly that proportionality limb needs to be bolted on here to the four-stage test. Because, and we say that, and this brings me on to my fourth submission.
Sorry, can I just pause again?
Yes, of course.
When you say they wrongly merged the tests, can I ask it this way?
Yes.
What is the difference between the tests that you say is implicit, you're saying is significant?
Well, the difference is extension of time is 4 stages, which seems to be firmly established in the Eastern Caribbean. What my learned friend Ms. Pennington-Benton has outlined is the test for strikeout for abusive process and want of prosecution. It's the common law framework. There is, of course, the CPR cases that Ms. Pennington-Benton has been through, but they are different. And certainly those latter tests do carry with them an import of proportionality.
But what's the critical thing missing if you merge the two?
Well, the critical thing missing is that the proportionality consideration, certainly the prejudice to the claimant or whoever it is that is responding to an application to strike out, that's missing from the 4-stage test, because it seems that, notwithstanding Justice of Appeal Michel refers to prejudice to the litigants, he focused entirely on prejudice to the respondent. And it seems that is the way in which it has been dealt with in the 4 stages. So that's missing.
Right. Anything else?
Sorry. Well, yes. As I say earlier, you do need to establish as an historian an abuse that's more than just mere delay, more than inordinate excusable delay. It needs to be a factor additional that goes above and beyond that, be it what the factors we've looked at already. It might be warehousing and so on.
Or just breach of the rules.
Or breach of the rules. And I understand we would, of course, accept that that has been, there are recent cases, I know that the board has been referred to them, Wynne, for example, in 2014. It's quite a stark case, quite different, we would say, on the facts. I might just deal with it briefly, which is, that case concerned, as I remember, a case that was issued in 2000, and subsequently, many years later, having been ordered by Mr. Justice Park to comply with timetables in 2001, they actually seek to amend their case in 2013 to introduce a whole new set of allegations, relied on an expert report that was defective in many respects, and those expert reports allege findings of fraud, forgery, tampering. You have a very different set of findings from Mr. Justice Barling in that case. We say that it's very different to the facts of our case. It cannot be said that we've been using expert reports inappropriately or, other than mere delay, doing things that transform the delay into abuse quite in the manner that it was found to have transformed abuse in Wynne. The authority for that, just so the board has it, is supplemental 188 to 200. Sorry, that's not the, that's incorrect. It's 145 to 178. In respect of the 4th submission, which is that the correct approach is still the 4-part test, but with the added layer of proportionality and alternatives, I do wish to take the board to a number of cases from the Eastern Caribbean to make good that submission.
I think that's why I was asking what the critical difference
Yes.
is, because I think, as I understand it, you're saying you consider proportionality in each case.
Well, you certainly can. I put it this way, my lady. The effect of not granting an extension of time in this case would be that you confine the appeal to the dustbin. It would be gone.
Well, indeed.
So that's the consequence.
Yeah.
And
But
that is...
the court clearly shouldn't be blind to that
No.
point.
It should, as we say, consider that in the round in its discretion.
So the 2 tests are the same then, aren't they?
Well, no, we don't accept that.
Okay.
4 stages, considering delay, merits and prejudice, they have quite, as it were, multifactored elements to it. But the abuse line of authorities is first got to find an abuse. Mere delay isn't enough. You've got to find an additional factor that transforms it to an abuse. Then you go on to proportionality. They are not the same. There's no proportionality within Mondesir, which is the case I took you to earlier of Justice of Appeal Michel. At no stage there does he consider, following this case, the proportionality principles. He simply applies the merged tests, the 4 stages, no proportionality, no alternatives. And we say that that's not an appropriate way to handle this factual reality. So if I can go to some of the earlier cases of the Eastern Caribbean, firstly at 2472, the case of Michael Baptiste, 2472. Sorry, it's actually slightly earlier, I believe. It's Respondent has a right to. Paragraph 22 is actually where I want to go, which is at 2471, just at the top of 2471. I just want to read out this passage. This was an appeal concerning strikeout of a notice of appeal for failure to file a skeleton argument. and it was considered to be draconian and disproportionate. And what you have there is Justice of Appeal Edwards stating quite clearly, the respondent has a right of appeal, and there is nothing in the language of the relevant statute or rules which suggests that an appellant who has failed to file the skeleton argument in time is to be debarred from prosecuting the appeal. Such default appears to me to be an irregularity which may be cured by the court by simply having regard to the overriding objective on an application for an extension of time. So this is a case from 2006.
Paragraph was that?
This was paragraph 22, my lord, at the very bottom. And I should say that paragraph at the top also refers to the relevant part of the CPR 2000 I mentioned, which is 2612K. That is the paragraph where you can shorten or extend time for compliance. I should say, of course, that the Court of Appeal didn't consider that provision at all. It might be said against me that we didn't ask it to,
Yeah.
but it didn't. 27. Yes. 27. Yeah. Right. Well, this paragraph here is effectively, I think the gist is, where is the explanation?
Yeah.
And well, that might well be part of the four-stage test. It is. One looks at delay and then the reasons for delay.
Yeah.
We would accept that.
And even though it may at first blush seem draconian to strike out a notice
Yes.
of appeal in these circumstances, the court says it is a proportionate and justified thing to do. It's
Yes,
fair.
and that's a matter for the court's discretion, of course, but it needs to, as it were, go through the motions of applying the relevant principles before it comes to that conclusion. And the proportionality aspect was missing, we say, from the Court of Appeal's decision, and indeed the decision in Montesir.
Well, while it's in my mind, can I just ask for a piece of information? Subsequent to the judgment that we're looking at, I know that Justice of Appeal Michel was appointed as the acting Chief Justice of the Eastern Caribbean Supreme Court. Is he still acting Chief Justice?
Retired. I'm told he's retired.
Oh, he's retired now. Right, thank you.
I'm conscious of time, my lords, my ladies. I'm just going to move very briefly to the relief from sanctions points, and I can address these quite quickly. Of course, the fifth submission is we say there was no need for relief from sanctions in this case, and we say that with some confidence because clearly the status hearing order did not impose a sanction. There is no sanction imposed by the rules. I can give the relevant rules for the court's reference, which is Rule 26.7.1. This is 1643. It says very clearly, if the court makes an order or gives directions, the court must, whenever practicable, also specify the consequences of failure to comply. That's not what happened in this case. And therefore, we say that this isn't a relief from sanctions case. As my learned friend has already pointed out, the old rules are draconian. They're non-discretionary. In fact, they're put as such in many cases. And so to do so, and this is the case of Dominica Agricultural, Justice of Appeal Barrow, who appears to have been quite keen to apply relief from sanctions principles to many cases. He says that they are non-discretionary and there's real vigour to them. I can just give you the reference, which is Supplemental 82. The final submission, then, is that there is also no implied sanction doctrine in the Eastern Caribbean. And we would not only suggest that the Caribbean Civil Court Practice Note perhaps is either out of date or needs to include reference to the important authority of Matthews. I can take the board to that, though. I don't imagine it's going to be in dispute that says quite clearly that unless there's a specific provision of the rules that imposes a sanction or that a sanction has been imposed, you can't imply one. That was all about a failure to file a defence. We put that in the supplemental bundle, pages 28 to 30. It's later approved again by the board in Crick and Brown, paragraph 24, page 70. And I just want to take the board to the case of KMG International, which is Chief Justice Pereira, who of course sits on this board from occasion, paragraph 26, page 122 of the supplemental bundle. Having previously in the preceding paragraphs considered the case of Sires, and that case was the first category, I think it's fair to say, of implied sanctions being recognised in England and Wales. You also have the cases of Altamart and FXF. So there are very few cases that actually this jurisdiction has considered to imply sanctions, and that's the helpful authority of YESSS, some sibilants there intended, and that is a very recent Court of Appeal decision of Lord Justice Baird, which says that there are basically three categories that have been recognised, and it's not appropriate to simply add to them unless there's a clear need. But at this paragraph...
What paragraph was that?
That is actually that's in the supplemental.
Yeah, what paragraph? Just give me the paragraph reference.
Yes, so that particular paragraph would be paragraphs 27 and 33. 33 says, if there's no such express sanction, then outside the third category identified in FXF and the specific recognised instances of implied sanctions identified in Sayers and Altamart, there is no relevant sanction for the purposes of CPR 3.9. Now, that's an English authority, but in KMG, which is where I was a moment ago at 122, very clearly there, Chief Justice Pereira says that the debate about implied sanctions in the Caribbean has been put to rest by Karen Matthews. So that concludes our submissions on extension of time and relief from sanctions. Unless the board has any further questions, then I think are we done with our time?
No, I don't
I'll hand
think
over
so.
to Respondent. Great.
Thank you very much, Mr. Lear. Yes, Mr. Hawthorne.
I appear with my learned friend, Midge Morton, attorney at law of the St Kitts. We propose to make our submissions under three broad headings, which I'll briefly summarise. The first is the formulation of the legal tests. We accept that the test for abuse and the test for delay, want of prosecution, as it used to be called, could perhaps have been more clearly expressed by the Court of Appeal, but we submit that the tests which were formulated were in substance correct, certainly when applied to the facts of this case. In giving permission to appeal, the Court of Appeal, Justice of Appeal Ventos, invited the board to restate the tests. If the board accedes to that invitation, we submit it doesn't follow that the Court of Appeal's conclusions in the present case were wrong. That would be our first submission. Our second submission will relate to the application of the tests to the facts. And again, we accept that the Court of Appeal judgment could have been more clearly expressed, but we submit that the court reached a proper conclusion in respect of both limbs, that is, abuse and want of prosecution. And our third submission will relate to the exercise of discretion. And we submit that there is a high threshold before an appeal court will overturn the exercise of a discretion by a lower court. The appellant has to establish that the Court of Appeal exercised its discretion in a manner which was irrational, and he has failed to establish this.
And I think now it's conceded that they're not arguing that.
Yeah, I'm grateful. So, moving to our first submission, which is the formulation of the legal test. And I'll divide that into four parts. I'll look at the test for abuse. I'll look at the test for want of prosecution. I'll look at the test for exercising a discretion. And I'll look at the note to CPR 31.10. So far as abuse of process is concerned, my lords and my ladies have indicated to my learned friends that this is really all about the construction of the new rules, and that it's not necessary to go back to Burkitt and James. We are very happy to deal with it under the new rules. We say Burkitt and James sets out the common law position, although when it comes to exercising discretions, that of course has to be done in the light of the overriding objective. The common law still exists, and if there are any gaps in the rules, then it's relevant to refer to the common law, and if the Court of Appeal referred to the common law when actually the same is achieved by the rules, it's not a very attractive proposition for my learned friend to say, oh, but you should have relied on the rules and not on the common law. It comes to the same thing, in other words. So one example of where there might be a difference, and we don't say there is a difference, but we accept there might be, is Rule 26.3, which we have on page 1639 and 1640. And sub-rule C says the statement of case or the part of it to be struck out is an abuse of process. And the argument might be there has to be something wrong with the statement of case itself rather than with with the appeal, the underlying appeal, becoming an abuse. We say the rule ought to be more broadly construed so as to cover the position, but if there is a gap, then there's room for the common law of abuse to apply. And abuse was, of course, goes right back to the classic statement of Lord Diplock in Hunter. The examples are manifold. There's no defined categories of abuse. But, of course, there are many categories, and it's all to do with misusing the court procedures. We say that one kind of abuse is warehousing, which is likely to be a matter of inference. The point about warehousing is that, as often is the case with fraud, the party who delays is hardly likely to advertise the fact that he's delayed. So it then becomes a matter of, is that the proper inference to draw? And of course, if there are other inferences that are innocent inferences, then the court, just as with fraud, the court shouldn't draw the inference of warehousing unless there is no other explanation. Grovit itself was a case where the warehousing was inferred. It wasn't. There was no positive evidence to that extent. If I can take you to our case at paragraph 27.
But you didn't run this below.
We didn't expressly run the point,
right.
But what we do submit is that it was clearly before the court that there had been, I think the way it was put, I'll take you in a moment to the Court of Appeal judgment. We submitted that there was an indifference to prosecuting the appeal, which we say is warehousing by another name. But I'll cut to that in a moment.
But delay involving a wholesale disregard of the rules would also be an abuse, wouldn't it?
Yes, absolutely.
And you don't have to label it as warehousing.
Indeed, indeed. But my lady, in typical barrister's fashion, if we've got three possible points, I want to make all of them. It may be that it's enough to characterise it as wholesale abuse, wholesale disregard of the rules. But in Grovit, I quote from Lord from the House of Lords, 1997, where it was said the judge struck it out saying he was satisfied the plaintiff had literally no interest in actively pursuing the litigation, and on appeal, the Court of Appeal said it was proper to infer that the motive was an abuse of process. And Lord Wolfe accepts that. So what we're saying is we don't need any more evidence. It's all there in the fact that there was this long delay and there was no proper explanation. My lady Simler pointed out that the the record of appeal had been available to the appellant since April 2020. It was only produced in August 2021 when we asked what was happening, and even then they didn't tell us they'd had it for all those months. And no explanation has ever been given for that. So we say we're in that territory where it is proper to infer that there is no proper explanation for it. In answer to the question whether it was raised, but from Lord Hamlin, was it raised before the Court of Appeal? Paragraph 14 on page 392 of the judgment, the Court of Appeal says, the respondents contend that the apparent indifference which the appellant had shown towards prosecution of the appeal, ignoring the rules, failing to honour its own undertakings, constitutes an abuse of process. So one could call that wholesale disregard, or one could call it warehousing. To the extent that there still remain two categories, in other words, abuse and want of prosecution, it's clear that want of prosecution, mere delay, is not sufficient without an extra ingredient, which is either prejudice or a fair trial no longer being possible, which perhaps may be another form of prejudice. In the case of abuse, there is no need to show prejudice. So it is important to show that there are slightly different considerations. The abuse itself is what makes the court decide that the court's procedures have been misused, and therefore the appellant should not be allowed to pursue his appeal. So there is no need to show prejudice to the defendant, to the respondent. If we turn then to what the Court of Appeal said in its judgment at paragraph 47 of our skeleton of our case, 47.3. Yes, we refer to paragraph 31 of the judgment, which contains mention of Lord Diplock. Any court, and then they quote the key passage from Lord Diplock in Hunter. So we say, although it's very compressed, that is the essential definition of an abuse, and that was firmly in the court's mind. And we therefore submit that the Court of Appeal plainly had in mind the proper test for abuse. Turning then to want of prosecution. The board, in its communication with us last week, asked whether the same principles apply to an appeal, and we say absolutely. The overriding objective is exactly the same, and indeed, as we see from the Court of Appeal's judgment at paragraph 29, they refer to Rule 62.20 of the CPR, which says that the Court of Appeal has all the powers and duties of the High Court. So clearly the overriding objective also applies equally in the Court of Appeal. Our submission at paragraph 40 of our case is that the court's decision is based on, or the Court of Appeal's decision should be, and indeed was, based on delay in relation to the appeal, but delay in the context of all the earlier delays. Case. And we say that the same point applies not just to looking at whether the delay is sufficient, but also whether the prejudice is sufficient. We've quoted from Burkitt and James, and I rely on Burkitt and James to this extent, although matters have moved on and the court now pays more regard, is really looking at the rules and the overriding objective. The position certainly hasn't improved for dilatory appellants from what it was in Burkitt and James. So I can rely on Burkitt and James at least to that extent. And the point which we quote in paragraph 25 of our case, the second paragraph that I've quoted from Lord Diplock, to justify dismissal of an action for want of prosecution, some prejudice to the defendant, additional to that inevitably flowing from the tardiness in issuing the writ, must be shown to have resulted from the subsequent delay. The additional prejudice need not be great compared with that which may already have passed. So what he's looking at there is if you issue your writ, as it then was, right at the end of the 6-year limitation period, and then there's some delay afterwards, the court can't strike out the case simply because you waited till the very last day before issuing. But if the combined prejudice of waiting 6 years and delaying a bit afterwards is serious, then the bit that's afterwards itself doesn't have to be serious. And we say that is very much still relevant and is applicable in the present case. And of course, the alternative to prejudice is to show that a fair trial is no longer possible. If we look then at how the Court of Appeal interpreted or set out the test for want of prosecution, I refer to this in our case at paragraph 48. I'm afraid there's a typo. My automatic paragraph numbering didn't work. And the error reference source not found should be paragraph 36 of our case. What we are saying in substance is that the 4-point test really comes to much the same thing as the classic test formulated by Lord Diplock. We say the test is differently structured from Burkitt and James, but as far as this appeal at least is concerned, the question is whether a formulation in accordance with Burkitt and James would have made any difference. And then there is the further question, even if it would have made a difference to formulate the test differently, is there a real likelihood that it would have led to a different outcome? And we say no.
What's wrong with this test? It's been frequently applied.
It has, and as my Lord was saying before, that is the local law applied in the Caribbean. We're perfectly content with that test, right. As indeed was the appellant on the appeal.
Yes.
We refer in our case to the passage in the appellant's skeleton argument in the Court of Appeal where they accept that the test is the correct one, and perhaps I can just, without taking you there, note it for your Lordship's notes that the same point was made. The same point was made in submissions in the Court of Appeal when they accepted in submission, Mr. Guthrie, late Mr. Guthrie, QC, accepted in submissions that the 4-point test was the right test. The only thing he disputed was that it referred to prejudice to the respondent, and he said you also have to consider prejudice to the appellant. Of course, we accept that, but what we say is the test is the threshold. The threshold does not involve prejudice to the appellant. It's only prejudice to the respondent that's mentioned in Burkitt and James. And then after that, one comes to the second stage, which is how to apply the discretion. And of course, at that stage, one does look at a prejudice to both parties. So the passage I had in mind is, for your Lordship's note, is page 1192 of the
1992.
1192.
1192.
And it's where Mr. Guthrie is making his submission to the Court of Appeal. Oh, sorry, not Mr. Guthrie, it was Mr. Hamel-Smith on that occasion. Mr. Guthrie had appeared in the court below, yes. It was Mr. Hamel-Smith, sorry, on that occasion. At 1192, line 20. Now, the common ground is complete with respect to the first 3 of the 4 principles. that is what you have, that what you have, that amounts to factors that the court has to weigh: length of delay, reasons for delay, and merits of appeal. With respect to the fourth factor, there is partial common ground, and then he goes on to say that you should also consider the prejudice to the other party. So we say, although the test is put in a different way from Burkitt and James, it really does come to much the same thing. And we don't ask the court to interfere. The only reason I went further into that was because Justice Ventos had invited the board to restate the test if they thought fit. But we're perfectly content for the Court of Appeal test should remain as it is. Of course, there is that only the threshold, and one then has the discretion to liaise.
And it doesn't rule out the possibility in a particular case if there's another relevant factor outside.
One isn't saying it's hidebound by these four factors. Absolutely not. No. And then the next element is the test for the discretion and whether that was correctly exercised. And my learned friend focuses on prejudice and on proportionality, although it does appear that they're really two ways of saying the same thing. Prejudice, of course, we accept prejudice to the appellant is relevant at the discretionary stage, and that, of course, nowadays, one is not simply looking at prejudice, as my Lord Lord Reed said. Things have moved on since Lord Bingham's time in Costello. One isn't simply looking at prejudice as between the parties, but also to the court and to other court users. May I take you to show how the Caribbean courts approach that matter to page 1838. And that is the decision in Barbados Refuge. It starts at it starts at 183. That's right. And it's Caribbean Court of Justice in 2006. And if the Lordships would go near the end, please, to page 1863. And I invite you to look at paragraphs 45 and 46. Yes. What I draw from that, firstly, 45, between A and B, the point is made about fairness being also fairness to other litigants. And then it's between B and C, that they talk about loss of crucial documents which are not disclosed within the time prescribed by an order for discovery and are subsequently lost and destroyed, albeit without fault on the part of the non-disclosing party. So that, of course, is directly applicable here to the mould outbreak. Mould outbreak was in June 2022. Coincidentally, yes, it was in June 2022, which was 2 years, exactly 2 years after the date when the record should have been filed. And if the record had been filed on time, who knows what other documents might have existed? And that's the point I want to come back to. And then in paragraph 46 at letter E, they follow the view of Lady Justice Arden, as she then was. The fact that a fair trial is still possible does not preclude the court from making a strikeout order. So it's clear then that abuse is different from want of prosecution leading to prejudice, or the fact that you can't have a fair trial. So we submit, and we do this by reference to our case at paragraph 72. We submit that, as Lord Hamlin has pointed out, at no time did the appellants ask the court, invite the court to make a lesser order. We say that when the court referred to the nuclear weapon, they may well have had in mind the observation of Lord Mance. Your Lordship will recall you were shown the case of Lord Mance earlier, where he referred to the court's nuclear weapon, and that was echoed in Justice Michel talking about a nuclear option. And of course, Lord Mance, when he did that, was saying that is the last resort. It is the nuclear weapon. After the court has decided that no other consequence, no other outcome is appropriate. And we say that when the court uses that shorthand nuclear weapon, it's very likely that they would have had that in mind. I've looked at Mr. Hamel-Smith's skeleton argument for the Court of Appeal to see whether he comes anywhere near suggesting a lesser sanction, and the nearest I can find is paragraph 312 in his conclusion.
Page?
312, my lord. So he says, in weighing all the four factors, the court must ultimately exercise its discretion in furtherance of the overriding objective.
Sorry, where are you? Which paragraph?
This is paragraph 85
Okay.
on page 312. And he says it wouldn't be appropriate to exercise the discretion to strike out. More appropriate exercise of discretion would be to fix some dates by which they must file their arguments. He doesn't even suggest an unless order. That's the nearest he comes. And as far as I can tell, in his oral submissions, he did not address the point at all. The focus of his oral submissions was almost entirely on his argument, which Lord Reid was unimpressed with, that the period should run from June 22 and not from June 2020. So it's fair to say that the Court of Appeal did not specifically refer to proportionality, but we submit that it doesn't follow that they didn't have it in mind. We refer in our case to the well-known dicta of Lord Hoffman in the Pigloska case, which the court will be well familiar with, and also with Lord Briggs's dictum. Let me just find that. Lord Briggs in Bergen and Evans, this is in paragraph 9.3 of our skeleton. The board's restraint when dealing with issues of civil procedure in other jurisdictions. And we say, with that in mind, there's no need to depart from the four-part test that's been consistently applied in the Caribbean. We say it's clear that from the judgment, paragraph 52, when they say the pertinent facts justify the use of the court's use of its nuclear weapon, that was an exercise of discretion, and the term nuclear weapon clearly has connotations that it's the very last resort, and therefore the court had this well in mind. I can just deal extremely briefly now, before the short adjournment, with Practice Note 31.10. It's common ground that reflects the old position in the Caribbean. It's been superseded by Matthews, but there is a proviso to this, that although the relief from sanctions is not directly engaged, what we say is that it is part of the culture of the Caribbean, and when one construes the overriding objective, one should construe it in the context of the whole of the civil procedure rules, which include the fact that getting relief from sanction is a lot more difficult in the Caribbean than it is in England and Wales.
Although that's now changed.
This was the law at the time.
I know.
This was the law at the time. And it'll take me more than a couple of minutes, so perhaps I should come back to the point.
Yes, very well then. Well, we'll look forward to hearing you at 2 o'clock. And the court, in the meantime, will adjourn.